In such contested proceedings, the judge could have been fully informed of relevant background on the defendant, as well as the nature of the seized materials. Without the affidavit, the defense does not know what disclosures were made to the magistrate in support of its filter plan. Here, too, the magistrate judge approved the filter protocol without input from the defense. The result is a protocol that is plainly ineffective. It simply does not ensure that the prosecution team members will not access or become aware of privileged materials, particularly as the filter team's leader is a deputy to the lead prosecutor in this matter. Next heading, fundamental fairness requires that this court appoint a special master. Courts considering analogous issues have appointed special masters, with one court noting the value of a special master in comparison with a filter team. In particular, this court and others have assessed the use of special masters following the execution of search warrants at attorneys' offices, contexts involving similar matters of privilege with far less historic importance. For example, in United States versus Stewart, No. 2-CR-395, 2002, WL 130059, parentheses, Southern District of New York, June 11th, 2002, and parentheses, the U.S. District Court for the Southern District of New York weighed an attorney's request for a special master after the government had searched her office pursuant to a warrant. Accordingly, that court considered the narrow question of whether seized material should be reviewed by a filter team or by a special master. The court appointed a special master, highlighting certain concerns inherent to any filter protocols, including the one presently in place, and the benefits of appointing a special master. Stewart, 2002, WL 130059, Act 7-8. The court also cited 3 other courts that had allowed filter teams to review seized materials and later opined that the use of other methods of review would have been better, id. at 6. For example, in U.S. versus Hunter, 13 F. Sup. 2D 574, 583, and N2 parentheses DVT 1998 and parentheses, the court noted with the benefit of hindsight that it may have been preferable for the screening of potentially privileged records to be left not to a filter team, but to a special master or magistrate judge. Ultimately, the Stewart Court appointed a special master with the authority to determine responsiveness, privilege issues, and whether any valid exceptions to privilege exist on fairness grounds, id. at 8-10. In appointing a special master, the court noted the importance of establishing a procedure that was not only fair, but also appeared to be fair, adding that the appearance of fairness helps to protect the public's confidence in the administration of justice and the willingness of clients to consult with their attorneys, id. at 8. See also in matter of search warrants executed on April 9th, 2018, No. 18-MJ-3161, parentheses, AD, New York, and parentheses. Similarly, appointing a special master to review documents seized from attorney's office in light of both families and the perception of fairness. United States versus Abel, 914 F sub 519, comma 519, parentheses, Southern District of Florida, 1995, end parentheses, and in parentheses, finding that the responsiveness and privilege issues raised following the seizure of materials from a law firm are exceptional and warrant referral to a special master, end parentheses. As a general matter, given the circumstances here, a taint team is insufficient. The appearance of justice must be served, as well as the interests of justice. It is a great leap of faith to expect the members of the general public would believe that any such Chinese wall would be impenetrable, this notwithstanding the honor of an Assistant United States Attorney, Stewart, 2002, WL 13000059 at 8, citing in search warrant for law offices executed on March 19, 1992, 153 FRD 55, 59, Southern District of New York, 1994. This matter has captured the attention of the American public. Merely adequate safeguards are not acceptable when the matter at hand involves not only the constitutional rights of President Trump, but also the preservation of executive privilege. Movement submits that the appointment of a special master is the only appropriate action, and for it to have any meaning at all, a protective order should issue ordering the United States to cease review of the seized materials immediately. C. The government must provide an informative receipt for property. Rule 41F of the Federal Rules of Criminal Procedure requires the law enforcement leave a receipt for property with the person from whom the items were seized or at the location of the search. Federal Rules of Criminal Procedure 41F1C and Rule 41FB states inventory, and an officer present during the execution of the warrant must prepare and verify an inventory of any property seized. The rule does not dictate creating an inventory, but requires that it be verified, a term that suggests some assessment of the contents of the receipt. The rule further requires that the officer execute the warrant promptly, return it, together with a copy of the inventory, to the magistrate judge designated on the warrant. Federal Rules of Criminal Procedure 41 F1D. On request, the judge must give a copy of the inventory to the person from whom or from whose premises the property was taken. Attached hereto is Exhibit 1 are the 3 pages of receipt for property left by the agents following the search of the former president's home on August 8, 2022. The receipt lists 45 entries describing items as a box labeled and parentheses number or binder of photos, in addition to documents that are variously identified as marked secret, top secret, and confidential, combined with sealed search warrant affidavit. This receipt does little to identify the materials that were seized from President Trump's home. This level of detail does not meet the standard of verification required in Rule 4B1F. An inventory of property seized is ministerial. United States versus Robinson, number 0860179-CR 2008 WL 5381824 at 9 to 10, Southern District of Florida, December 19, 2008. However, it is a matter of fundamental fairness that the agents at least identify from what locations each box of documents was seized, whether these boxes were at the location or were boxes that the agents bought with them and filled. Whether other items were contained in those boxes, whether confidential labels were based upon labels imprinted on the documents themselves, or whether the return label was the result of a review of presumptively privileged executive communications to make that determination. Movement submits the current receipt for property is legally deficient. Accordingly, the government should be required to provide more detailed and informative receipt for property, which states exactly what was seized and where it was located when seized. In addition, movement requests that the court provide him with a copy of the inventory. This, along with inspection of the full affidavit, is the only way to ensure the president can properly evaluate and avail himself of the important protections of Rule 41. 4. Conclusion. For the foregoing reasons, President Donald Trump respectively requests that this court issue an order that A. Appoints a special master, B. Enjoins further review of seized material by the government until a special master is appointed, C. Requires the government to provide a more detailed receipt for property, and D. Requires the government to return any item seized that was not within the scope of the search warrant, respectively submitted. Lindsay Halligan, dated August 22nd, 2022. Certificate of service. I hereby certify that on this 22nd day of August 2022, a copy of the foregoing motion for judicial oversight and additional relief was served via electronic mail on counsel for government as set forth below. Served on Juan Antonio Gonzalez, United States Attorney, Florida Bar, and J. Brett, Chief, Counterintelligence and Expert Control Section, National Security Division. Exhibit 1, receipt for property, 2 pages. That is the reading of the request by Donald Trump, who is not president when he filed this. He is former president of the United States, but he set up a fake presidential office at Mar-a-Lago, his social club, and I think he still thinks he is still president of the United States. Melania Trump felt violated, and she felt that the officers had touched her underwear, so she went out and bought some more underwear. And Donald Trump, several days later, said that the officers had been in Barron Trump's room, which would be foreseeable because many criminals hide their evidence covered by children and seniors. It's pretty amazing. They've been able to find evidence of drugs and papers and so forth in baby diapers and everywhere on, cute little grandma or granddad. So, unfortunately, when there is a warrant served, the kids, the whole family, do become involved in a house search. And although we would like to have certain people excluded, they are not excluded because criminals hide stuff everywhere, under floorboards. And why did Trump have among his documents a report on the French president? I'm going to read that from his receipt of documents. One document was executive grant of clemency regarding Roger Jason Stone Jr. Another item, information regarding President of France. And it was said they did a investigation of the President of France and they were trying to find out who he was having sex with outside of his marriage, if anybody. And then, of course, all the other documents, boxes, miscellaneous things they found. They did not describe having taken Melania's underwear anywhere in that list of documents taken. Anyway, I'm not going to review this. My voice is gone, and we can talk about this more thoroughly in what he said in his request for a special master at another time. You can evaluate this for yourself. Well, have a great day. Please like and subscribe. Thanks, and we'll see you later. Bye.